Welcome to Shaping Canada, 150 years of landmark decisions. The Canada we know today wasn't built by chance. Argument by argument, judgment by judgment. It was forged by law within a unique justice system born from the union of the civil law and common law and increasingly indigenous legal traditions. In this series, we mark the Supreme Court of Canada's 150th anniversary by decoding some rulings that defined our rights, our freedoms, and our collective identity. From criminal law to indigenous rights and the division of powers, the decisions we chose to share with you are not just ancient history. They still shape our reality today. I am your host, Hugo Martin, and I ask you to join me for exclusive conversations with the 9 justices of the Supreme Court and leading constitutional experts as we uncover the context, the impact, and the lasting legacy of these judgments. Madam Justice Karakatsanis, welcome. Thank you for being with us. Merci de participer à façonner le Canada 150 ans de décisions marquantes.
Merci à vous. C'est un plaisir.
It is a pleasure to speak with you as the first Greek-Canadian justice and the court's current longest-serving justice of the Supreme Court.
It doesn't always feel that way, but sometimes it does.
Your career path is remarkable for its diversity. It includes private practice in criminal, civil, and family law, followed by 15 years in senior leadership roles within the Ontario Public Service. This path culminated in your appointment to the Ontario Superior Court of Justice in 2002 and the Court of Appeal for Ontario in 2010. Throughout your career, you have been recognized as a pragmatic jurist, deeply committed to making the justice system more accessible. And we'll get to this a little later. This is a theme evident in your use of clear and direct language in your judicial decisions. Your judgment often had a profound impact practically. I'm thinking, for example, Hryniak v. Malden in 2014, which you authored, and which reformed how our courts approach civil disputes to promote more timely and affordable justice. It was as early as 2014. I also think of your work in court cases like R v. Goldfinch in 2019 and your partial dissent in R v. Boutillier in 2017, where you provided guidance on issues from protecting complainants in sexual assaults to safeguarding the charter rights of offenders. Speaking of Hryniak v. Malden, you wrote that a shift in culture is required. You championed the principle of proportionality, stating that the best forum for resolving a dispute is not always that with the most painstaking procedure, and calling for proportional procedures tailored to the needs of the particular case. This was a call to move the system away from the conventional full trials as default answer in favor of more affordable, timely, and just ways to adjudicate claims. What drove you to author such a strong, unanimous call for this cultural reform?
Well, thank you. And thank you for having me on this podcast. We all bring our experiences and our perspectives with us to this job. And there's no doubt that my different experiences in the justice system is something that informs the way I do my work. So I had witnessed firsthand the struggles of ordinary Canadians in accessing affordable and timely justice, both in their individual cases, but also from the perspective of the justice system. As a lawyer and adjudicative in an administrative tribunal and in the courts, I saw the procedural delays and barriers for the litigants. And then as Deputy Minister of Justice, with responsibility for the administration of the courts and oversight of tribunals, I approached those challenges from a different perspective, from legal policy and systemic efficiency and accountability. So any kind of legal rule has to work at both a principled systemic level. It has to be coherent, but it also has to work on the ground. It has to be something that judges can apply. It has to be something that works for the person, the people who are at the heart of our work. So Hryniak was about one rule of civil procedure in one province. But the court saw Hryniak as the means to call for a culture change, to try to address the challenges of access to justice by giving judges flexibility that they needed to work within the civil processes of all jurisdictions, by emphasizing the need for the process to fit the particular case. I have to say that Hryniak, I think, is one of our most cited cases, and a decade later, I still get judges and lawyers thanking me for the procedural flexibility. They felt that they could take responsibility for their cases. As for the question why, in the judgment itself, we say, without an effective means of enforcing rights, the rule of law is threatened.
This court has been a champion of making the justice system more accessible and more timely. This was as early as 2014 in a civil case. So we're not just talking prosecuting faster. We're talking about how can we make this system accessible and timely, including the civil system. I think it was very inspiring. And I must say that Hryniak, for myself, I like to throw it in when I plead once in a while. But I always try to remind our deciders that Hryniak exists.
You know, I mean, I think we sometimes forget that the justice system is there for people, and that if someone feels that they've been treated unfairly, unjustly, that really gets in the way of their living a good life. So sometimes it's a good reminder.
I'd like to turn to your work in criminal law and talk about R.V. Goldfinch, not the book.
Nor the song.
You wrote for the majority, ruling that the label friends with benefits to describe a relationship could not be admitted simply as context. So you found that it risked inviting the jury to engage in harmful and discredited myths about a victim's sexual behavior. This highlights the immense challenge of balancing an accused's rights to a fair trial with the need to protect a victim's dignity, privacy, and their right to a trial free from discrimination and stereotypes. Could you walk us through why it is so critical to prevent these myths from undermining the truth-seeking process?
Right. Well, thank you for that question. I'll start by saying I love the criminal law. I always have. It raises fundamental questions about the kind of society we want to live in, about the rights and freedoms of individuals on the one hand, and our right to a peaceful and safe society as well. So it is all about balancing these complex and sometimes competing rights. And I've loved criminal law since law school and throughout my career. Sexual assault cases raise additional concerns, not only about an accused person's right to full answer in defense, and of course the presumption of innocence, but also about the dignity and privacy of a complainant. And I did many sexual assault cases as a trial judge, and they were challenging. But the focus of every criminal trial is truth-seeking. Criminal trials call for evidence. There's no room for myths, especially those based on a victim's sexual behavior. So Goldfinch, I think, really recognized how insidious those myths can be. It was the evidence about, prior sexual activity between them and its relevance to the issue of consent. And by focusing on the modern definition of consent, and on really telling judges that context could not be a substitute for precision in identifying precisely how sexual behavior can sometimes be relevant. So it was a reminder, yes, of the importance of an accused person's right to a fair trial, but also, as you said, the profound need to protect the victim's dignity, privacy, and the right to a trial for all, for society that is free from discrimination and stereotypes.
I'd like to turn to another area where you've written about the government's power in the sentencing process, the punishment to impose on a criminal. In your partial dissent in R.V. Boutillier, which I think should have been the majority opinion.
I feel that way every time I write a dissent.
But you raised an alarm about the law that allows a court to designate someone as a dangerous offender, the labeling of The criminal code at the time was modified by changing the word may to shall, and therefore removed the judge's discretion, I would say the option, and as a result, more or less, forced them to impose what could be a grossly disproportionate and unconstitutional sentence of indefinite detention, even if the trial judge felt it was unwarranted. This speaks directly to your concerns about state powers, which you've raised in other dissents. Could you elaborate on the importance of discretion as a charter safeguard in our justice system?
Okay, thank you. Well, the Charter has given judges both the responsibility and the duty to ensure that state powers and legislation comply with the Constitution. So we are asked sometimes to strike down legislation that's passed for public safety purposes. That is a job that the Charter gives us. So we start by looking at the underlying principles. We value an individual's rights, but we also, as I said earlier, want to live in a safe society. So it's a fundamental principle of criminal law that a person is punished for their moral blameworthiness and the gravity of the offense. Our criminal law has always been built on a strong tradition that the punishment must fit the crime. So dangerous offender applications kind of sits at the convergence of all of these competing principles and interests. And the idea of indefinite incarceration was new with the dangerous offender regime, and indefinite incarceration not for what the person has done, but for what they might do. I think that makes them particularly challenging. I signed off on dangerous offender applications when I was a Deputy Minister of Justice, the Deputy Attorney General in Ontario, and I dealt with them as a trial judge, and of course now as an appeal court judge. But you ask about judicial discretion, and judicial discretion can be a safety valve, as our court has said in the context of minimum sentences, and it can be a way to preserve Parliament's policy choice while still permitting a judge the discretion in an exceptional case where the decision would breach the individual's constitutional rights. So, that's something that our court has set out in its jurisprudence. Judicial discretion, the trial judge at first instance, that's deeply ingrained in our system of justice and our system of criminal justice.
So adding that word or changing the word from the judge may impose a sentence to shall impose a sentence, that would be kind of removing the judicial discretion. And you raised the flag or
right.
in your dissent.
Well, that's what the dissent said.
Yes.
The majority. Well, they explained their decision.
Yeah.
That happens. We often have split decisions.
We talked at length with your colleagues about the split decisions and about how this process works. And this is part of, I think, the beauty of the court.
Yeah, I think so. But I think it's also part of charter cases, because charter cases do actually talk about values, fundamental values, and often they're in tension with one another. So I think it's understandable that reasonable judges can come to different conclusions about how those values play out in a particular case. And that's why I think it's just so important that we are transparent in our reasons and we identify what are the principles, what are the values that we are taking into consideration, and how is it that we balance them. But it's part of the work. It's inherent, I think, in the nature of charter decision-making that reasonable judges can disagree.
Madam Justice, you have been on the court since 2011, a period of incredible societal and technological change. From this unique vantage point, and given your personal commitment to access to justice, you have seen the court's role, or perhaps its approach, evolve to meet the modern needs of Canadians. Is the justice system, from the court's perspective, becoming more accessible?
Well, I think in terms of the Supreme Court of Canada, there's no doubt that the answer is yes. I'll start by the way we write our decisions. We do write for the public as well as for the lawyers and the judges. And we use plain language so that people can understand. I write an overview that will tell a layperson what the case is about, what I decide and why I decide it. we're very much aware that what we write is for the public. It's part of the accountability of the court to explain our decision making in a way that the public can understand. We're generous in allowing interveners to make submissions before us, from academics, from social society organizations, governments, other organizations, and their participation makes our decisions better.
Sometimes you even invite intervener.
Sometimes we do, because it not only makes sure that we understand the consequences of our decisions for a variety of different contexts, makes our decisions better, but I think it also brings legitimacy to our work. We are listening to the views and perspectives of groups and organizations from across the country. I think that is part of accessibility as well. Every decision we write, when we're making substantive decisions, we think about access to justice. Every decision in a Supreme Court, those that deal with procedure and process, and they have an obvious and direct relationship to cost and delay. But even in our most substantive legal issues, we need to consider not only what is most just in the circumstances, but how it will impact on people's ability to access resolution to their legal problems, as well as their ability to obtain a just result. So, there's always a range of possible decisions, from one that involves a complex, individualized hearing to something that's closer to a bright line rule. And those options, I think, are informed as well by what would work on the ground, what would be accessible. I should add that quite apart from my job as a Supreme Court judge, I chair the National Action Committee on Access to Justice on Civil and Family Matters. So in that capacity, I am involved with stakeholders and justice partners from across the country in trying to find ways to help people resolve their legal problems without going to court sometimes, if possible. So that's a much broader perspective. And even in that context, I have to say, because we're just now, this is our 13th year as a National Action Committee, I think it's fair to say that access to justice is part of every conversation in justice. So that's real progress. And there have been some really exciting initiatives across the country. But I think the consensus is there still is an access to justice challenge that we need to overcome, and we need to rededicate ourselves to.
Chief Justice Wagner has been very vocal about...
Our court, under his leadership, made it a priority to speak to Canadians about the nature of our work. Si je peux ajouter...
Je vous en prie.
Oui. Moi, j'ai consacré des décennies à promouvoir l'accès à la justice dans divers rôles. Et je suis convaincue que pour transformer véritablement la culture juridique, il faut envisager la justice du point de vue de celles et ceux qui cherchent à résoudre leurs problèmes. Pour moi, une vision de la justice centrée sur la personne se doit de placer réellement des individus, les personnes, au cœur de notre travail afin de bâtir une justice adaptée, inclusive et accessible.
Madame la Juge Karakatsanis, this podcast series is about 150 years of landmark decisions that have shaped Canada. Your own work often involved balancing complex rights. You talked about it earlier, from protecting vulnerable people to your notable dissents on state powers and the right to privacy in investigative contexts. As the court faces the next 150 years with challenges that we can barely imagine, from artificial intelligence to new issues of digital privacy, to access to justice, like we said, what landmark decision or core principle from the court's past formed the most essential foundation? And what part of that 150-year legacy will be, in your view, the most critical for navigating our future?
Okay, well, that's a big question. This is my 15th year on the court, and I've seen major societal and legal changes and some very big cases. There have been times when I've entered a packed courtroom with a real sense of history, recognizing that our decision was going to impact millions of Canadians. it really brings a profound sense of humility and responsibility. I mean, I'm thinking about cases like Carter, the right to physician-assisted death, Bedford, which recognized the need to balance safety and security of sex workers with public order. Jordan, giving effect to an accused's right to a trial within a reasonable time, and the public's interest in having cases decided on the merits, and obviously, key developments in Aboriginal law. These are cases that mark major societal and legal changes, and they involve controversial social issues. So, as I said, reasonable people, not just reasonable lawyers, can disagree on the right answers to these questions. So, in navigating the future, I think the key is to maintain the public confidence and the legitimacy of the Supreme Court of Canada. The public is increasingly skeptical of public institutions, and we cannot take that confidence and that legitimacy for granted. I mean, the court has no enforcement power. It has only its words and its integrity, and that requires public acceptance. So in our work, in our judgments, we've got to be both explicit and transparent when we answer these difficult questions so that the public can understand the answers and have confidence in our integrity in answering those questions. I think there are two aspects of the 150-year legacy that I would view most critical. First is the legacy of our charter jurisprudence. It is jurisprudence that is actually cited around the world, and it is rooted going back to first principles. What are the interests that the Charter seeks to protect? What kind of society was it trying to protect? As then Justice Brian Dixon said in Big Drug M, and I love this quote, "A free society is one which aims at equality with respect to the enjoyment of fundamental freedoms. The kind of freedoms the Charter protects must surely be founded in respect for the inherent dignity and inviolable rights of the human person." So going back to those first principles, identifying why these questions are so important, I think always helps guide you when you have to make some difficult choices. But those decisions can often run against public opinion, especially when they're about, individual rights or minority rights. Unfortunately, the public often sees these rights as rights of criminals. That's because many of them arise when someone is charged with an offense. But, I used to tell the high school students when I was a trial judge and they would come in to watch our charter motions, I used to tell them that we only hear about the cases when the police do a search and they find the drugs. That's when a charge is laid. We never hear about the cases where there's a search and nothing is found. So I would remind those students that it is those decisions that define the rights and limit the police powers, not for those accused, but for everyone. For them, for me, for our friends, our family, our neighbors. These are the fundamental rights and freedoms that belong to every person in society. And that's something worth reminding. But they show up in criminal cases. That's where these rights get defined. And the limits to state power get defined. So our charter jurisprudence, very strong, foundational, rooted in first principles, and I think it will provide a very strong basis for the future. And then second, I would add something that I've come to feel more strongly over time, and that is that the rule of law is about justice. And when we are articulating our reasons for deciding a case in a particular way, it's worth remembering that the rule of law is about more than just rules and more than about law. It's about justice. I love Martin Luther King Jr.'s reminder that the long arc of the moral universe must bend towards justice. Law is not just the rule of law. It must be a just rule of law. So I've been a judge for 23 years, and I've come to believe that the most important judicial quality is humility and humanity. because ultimately every law, every decision is about people. As judges, we must bring our independence of thought with humility of spirit, recognizing that justice is a common good and a basic human right. Pour moi, la primauté du droit, la règle du droit, n'est pas seulement une question de règles, ni une question de droit, mais c'est une question de justice. Nous sommes tous animés par l'engagement envers une société plus juste, qui contribue à une vie meilleure pour toutes et tous. La justice est un bien commun et un besoin humain fondamental.
Madame la juge Karakatsanis, merci beaucoup d'avoir partagé votre expérience avec nous, mais d'avoir aussi été aussi généreuse. Thank you.
Oh, thank you.
Thank you for joining us for this episode of Shaping Canada, 150 Years of Landmark Decisions. As we've explored today, the law is not static, it is living. Every Supreme Court ruling adds another stone to the foundation of our society. For links to the decisions discussed and more information about our guests, visit shaping-canada.ca and make sure to read the show notes. Subscribe on your favorite podcatcher so you don't miss any part of this series marking the 150th anniversary of the Supreme Court of Canada. Thank you to everyone who contributed to this project: the Supreme Court of Canada, the Right Honourable Richard Wagner, Chief Justice of Canada, the Honourables Nicolas Cazirard, Suzanne Côté, Andromache Karakatsanis, Sheila Martin, Malcolm Rowe, Mahmoud Jamal, Michel Obonzawin, and Mary Moreau, Professors Louise Langevin, Jocelyn Downey, Carrie Frock, Naomi Metallic, Karen Drake, Denis Nadeau, Félix Mathieu, Éric Labelle-Eastaff, Marcus Moore, Joel Bakin, Howie Kislowitz, Richard Moon, and François Tanguay-Renaud. Thank you to Maître Michel Lebrun, Miss Sandrine Raymond, Laurence Laperrière, and Laurence Thériault, Mr. Peter Warren, and our producer, Constance Saint-Pierre. This project has been made possible by the Government of Canada. I am Hugo Martin. Until next time.